For chapter 16, we kind of talked about the statute of frauds and kind of what that all covers. So kind of like what type of contracts must be in writing, if there's some exceptions to these requirements, what the statute of frauds considers to be adequate to fulfill the written document to be legal, and then what is parole evidence and why is it important in terms of statute of fraud. So statute of fraud, that's so the first thing we're supposed to talk about is the phrase always get in writing, and do we believe that that is prudent evidence? See, I've always kind of thought it was, because as long as it's written and there's a signed thing saying I put my signature next to it, or I put like an email, like I signed it like with writing my name there, that seems like prudent evidence that is a written that's a fulfilled contract, because I am admitting to these terms that's written in the contract, and admitting to that I'm going to do this in order to get this, or anything like that. I've always thought that's prudent evidence. If you always get it in writing, that's all you truly need. So statute of frauds, the main purpose of this is to prevent harm to innocent parties by making sure there's written evidence of what the both parties agreed on. So like there's a mutual agreement for these transactions, because usually in oral contracts it's kind of hard to make or to prove that these actually happen, but in a written contract it's kind of easy. It's a lot easier to prove it happened, because you got the contract, you have the signature, and that's pretty much all you really need to kind of prove that is actually a fulfilled contract or a fulfilled deal. So the type of contracts that must be in writing is contracts involving land, and that's to make sure that it's saying I purchased this land, and that's the same for anything you buy that's over $500. Like if you're gonna go buy a car, you have to fill out all these contracts saying I am purchasing this car, and I am showing that I'm going to be paying for this car, and that I will pay for it in order to receive this car. Anything that's usually any contract that's made that's usually got the end date after like a year, because then it's kind of for sure in written that, hey, this is gonna happen, this is the deal, like this is the contract, so it's in writing saying it's gonna happen. Now there are some exceptions to these in a way. So like there's partial performance, so there is like a specific performance of it, whether it's like in an oral contract, they may grant specific performance of an oral contract if the party can prove that part of the oral contract existed, of course, and it's just certain parts of it that's actually that they can prove actually happened. Usually that kind of just goes for oral contracts. Admitting to something, like if you're under oath saying I admit to agreeing to this contract orally, and then the courts can say this part of the contract or that whole contract is valid and not voidable, because it is now proven that you said under oath, because you're admitting to it. Another one is the promissory estoppel. This may be enforced in some states to recall that a person's justifiable relies on another's promise. So like if there's like a third party there, of course, like they can say, hey, yeah, they agreed to an oral contract, that this is that they both agreed to the terms and all that. So they can't deny that the contract existed. Now there are some things that must be in the writing to make it an adequate, fulfilled agreement. And that, of course, is the essential terms of the contract. So what's both parties are agreeing to. And then some indication that both parties agreed, whether it's a signature, like on a written form, or if it's by fax or email, like there's or I guess by email it'd be, like you can put your name under it, like you can send an email in with your name saying that you agree to it. That would be that'd be considered a signature to agreeing to it. And then as long as the terms are reasonable, like both like parties agree to the reasonable terms, like with certainty that they're going to, then it's a legal contract as long as they have all that. Now, parole evidence. This is the testimony or other evidence of communications between the parties that is not contained in the contract itself. So this could be negotiations prior to the contract, agreements to like prior to the official contract, anything that can happen before the contract that they both kind of agreed to. This can be considered parole evidence. And it's important because if they're able to prove that they agreed to it, and then it's like one of the parties kind of saying like they didn't agree to it later, then they can now the court can now make that part unvoidable, or make it so like that's actually in the contract as well, as long as they both agreed to it. So it's just making sure that both parties agree to, or that both parties do what they agreed to do. So it's not, so one party's not getting screwed over in a agreement.